IVM.
Welcome to Police Chowki, a special limited series on your favorite public policy podcast, All Things Policy. This series will take you behind the khaki uniform, beyond the flashing red beacon, and into the heart of the functioning of the Indian police force. We cast a critical eye on the role and function of the police in the Indian democracy, from the silent persistence of paperwork and meticulous investigation to risky counterterrorism efforts and policing in conflict zones. We explore the need for police reform and accountability in the system. Each episode brings you a comprehensive exploration of a unique facet of policing, illuminated by the insights of a former IPS officer who has lived the life behind the badge. So join us every Monday morning as we take you into the complex world of Police Chowki.
Hello and welcome to another episode of Police Chowki. Under the Indian criminal law, there is a presumption that children below the age of 7 cannot commit crimes, and those children between the ages of 7 to 12 are also considered incapable of committing crimes if they are not of a mature understanding. For those children between the ages of 12 to 18 who are in conflict with law, we have the juvenile justice system. About 20% of India's population falls in this age bracket between 12 to 18, and a large chunk of them are vulnerable. This makes a juvenile justice system, which looks at children in conflict with law and children who are in need of care and protection, all the more important. So to discuss about juvenile justice system in India, we have a very special guest on the show today, Ms. Shyni S, who is an IPS officer and currently works as the IG of training at the Biju Patnaik State Police Academy in Odisha. Welcome to the show, ma'am.
Thank you, Sri.
And we also have a regular guest on the show today, Mr. Javeed Ahmad. He's a former IPS officer and DGP of Uttar Pradesh. Welcome to the show, Mr. Ahmad.
Nice to be back, and great pleasure to welcome Shyni, a former colleague of mine. I'm sure her inputs today will be of great use to all our listeners. So a very special thank you to Shyni for joining us today.
Thank you so much, sir, and so nice to see you again after such a long time, sir.
Thanks for joining. So let's begin this discussion today with the principle of fresh start. And I want to start there because this is the foundation of the juvenile justice system. The principle of first start essentially emphasizes that once a juvenile completes their stipulated punishment, their record is essentially wiped clean, allowing them to reintegrate into the society without, carrying any baggage of their past offenses. And this principle of first start is internationally recognized, and the Indian juvenile justice system is also built upon it. So to set the context to our listeners as to what the discussion is going to be about today, I want to request you, Ms. Shyni, if you could, delve into the importance of this principle of fresh start and tell us how it fits into the objectives of the juvenile justice system in India and why is it so important?
Okay, Sri. The Juvenile Justice Act is a social legislation, and it's enacted with the noble objective of care and protection of children. And this is applicable to children in need of care and protection as well as children in conflict with law. Today we are going to discuss mostly children in conflict with law. We often fail to recognize that a child in conflict with law can also be a child in need of care and protection. This principle of fresh start is one of the 16 guiding principles provided in the beginning of the Act. The principle of fresh start means that all past records of a child in conflict with law is erased from all records. All records pertaining to his conviction is also erased and destroyed after expiry of the appeal period or after 7 years. This is to ensure that a child do not suffer any disqualification because of this conviction for some action which he had done during the period of adolescence. To that extent, the principle of fresh start is very important. This is an internationally accepted principle, as you said. But we need to understand the principle of fresh start, we need to understand why a differential treatment of a child is required. A lot of it is pure science. A lot of research has gone into how neurological aspects influence juvenile delinquency. Evidence suggests that there's something in the brain called as neocortex, which is responsible for reasoning and self-regulation. So this is the last to develop in human beings. So the research shows that this continues to develop till 25 years of age. So this is the time when the children mature. And during this phase, they display deviant behaviors which are excessively stressful, and the children are, what I'm trying to say is that the children are likely to display excessive risk-taking behaviors. During this period, they are more likely to deviate from the socially accepted norms. We need to but accept that such minor non-conforming youthful behavior or conduct is part of normal maturation process during adolescence, and such behaviors automatically tend to disappear as they grow into or transition into adulthood. So if we accept that this excessive risk-taking behavior or pleasure-seeking behavior, whatever it is, if it is due to something that is happening in the brain, then we can absolve a lot of their conduct as something that we ordinarily would do for our own children at home. The good part is that majority of the children who do this first time offending and come into the criminal justice system stay off from such behaviors in future if provided, even without any help also, but if provided the help, majority of the children would not re-offend. So that is why it is important that they be given a second chance instead of giving an opportunity to repeat such behaviors. So we need to handhold them and take them out of the process, during which time the adolescent will also mature into an adulthood and he is through with those kind of behaviors. That is why this principle of fresh start is very important, and all children to that extent, like our own children, deserve this second start, a second chance. I hope I have clarified your points, Sri.
Yeah, thank you. Thank you for that elaboration, because I think you covered pretty much why the entire system treats juveniles differently and why we have a separate system which takes care of them rather than, pushing them through the criminal justice system. But recently there have been developments where, the changes in law have been made to send certain juveniles to the regular criminal justice system if they are accused of heinous crimes and so on. But we'll come to that in just a bit. Before that, you mentioned the JJ Act, right? The Juvenile Justice Act of 2005. Now, this is the bedrock legislation of juvenile justice in the country. It covers the entire procedure from apprehension of a juvenile for any delinquent act till they are sort of rehabilitated and released, right? And it involves multiple stakeholders. You have the child welfare committees, you have the Juvenile Justice Board, which looks into the inquiry under this law. You have the police, you have NGOs, social workers, parents of the children. All of them are involved and they have their duties and responsibilities. So if you could quickly run us through, how does it work? In the sense, if say a juvenile commits a certain offense and the process gets kickstarted, how does it proceed and where does it end?
As you said, Sri, first there has to be a commission of an offense. So then the information, it's a fact that there are a lot of such commissions happening and only a part of it gets into the radar of the system. And this is true with adolescents, children, and this is true with respect to adults also. So when the information comes to the police, there are different ways in which a child is dealt, which is different from the adult system. That is why a separate act is there for the juveniles. So when an information comes, it would depend on the kind of information as to what the police would do. Like, for example, if the matter is, can I explain what petty, serious and heinous offenses are? Because only then one will understand the different methods in which police would respond differently. So there are three types of offenses as detailed in the Juvenile Justice Act. Petty offenses broadly means the offenses which have punishment or imprisonment up to 3 years. Serious offenses are those with imprisonment from 3 to 7. And heinous, we can broadly say it is 7 years or above, with a minimum punishment of 7 years or above. So if it is a petty and serious offense, the police is not supposed to even register an FIR. They are supposed to make a general diary entry and then apprehend the child if required. But I think we need not go into those nuances of it. Yes. In petty and serious offenses, the police need not even bring the child to the police station or like even apprehend the child. But in heinous offences, a child is generally produced before the JJB. In petty and serious offences, the police can apprehend the child if the police is of the opinion that such apprehension is in the interest of the child. Like a child is, the father of the child is engaging a child in maybe illegal activities. So it's not proper for the police to know that and then send back the child to his own parents. So in such cases, apprehension is required, but that apprehension is not similar to arrest. It's not a penalty or punishment. So it is to help the child, and to look after his welfare. So in after that, after meeting the police, then the next stage is whether the police would produce the child to Juvenile Justice Board. There is something called as a Juvenile Justice Board, and the primary responsibility of all stakeholders in juvenile justice is the care and protection of the child. So after the child is produced in the JJB, the child negotiates the system, and the board issues orders for his care and protection. The board should ensure that the educational requirement of the child is taken care of, his other requirements are met. So the board would pass appropriate orders as necessary. Or in case the board feels, so the Juvenile Justice Act details what are the kind of orders the board can pass before an inquiry. So it's basically aimed to help the child. And unnecessary detentions, the act, one of the principles of the act is that the institutionalization of the child or detention of the child should be a last resort. So ordinarily, on the first day of hearing, the Juvenile Justice Board disposes of the petty case matters. In other offences where board decides to hold an inquiry, the child will have to appear on whichever dates, and the parents have to undertake to produce the child before the JJB. And to help the child negotiate this process, there are like assistance that is to be provided by the state. The probation officer is there, the district child protection officer is there, the child welfare police officer is there. So they will all try to help the child go through this process. And after the inquiry, the court can decide whether the child is guilty of the accusation that is made against him or otherwise. Accordingly, appropriate orders can be passed by the Juvenile Justice Board. But other stakeholders in this, as you were saying, would also involve the childcare institution staff, the in charges of the observation homes. But once a child comes into the criminal justice system and goes back, in our society, there is a lot of stigma. So I would say that other than the formal institutions, the stakeholders in child protection would be also the parents, the family, the neighborhood, the teachers in the school and others. So all of them have to help the child negotiate the stage and come out as a reformed citizen.
Right. Mr. Ahmed, so I think Ms. Shyni has taken us through what happens in the juvenile justice process, right from the apprehension till the conclusion of the inquiry and what kind of punishment or measures that can be stipulated against the child. But I want to know from you from internal perspective of the police itself. So how are juvenile cases dealt with? Is there an in charge in every police station who takes care of these offences? What is sort of the setup there?
Ideally, in every police station, there are more than one, maybe a team of 2 or 3 police personnel who are trained to handle Juvenile Justice Act cases. They are trained in the processes, in the procedures, and also, most importantly, they are trained in how to handle a juvenile delinquent or someone who's in conflict with the law and he's a juvenile. That ideally is the position, and at least in the bigger towns, there is a unit for JJ Act matters in almost every police station. In the not so urban areas, the situation may be different. That has been my experience. Unfortunately, the kind of training to handle a child who's in conflict with the law is only very perfunctory or very basic for police personnel. So that is always an area where there is a substantial scope for improvement. In fact, the involvement of non-profit organizations and even the social welfare department of the government to continuously train police personnel in this aspect of their work is very important. Secondly, I would like to highlight, and I'm sure Shani will be able to tell us more about it. Once the child is produced before the JJ board, the question is, as she said, that whether the trial has to begin or the child has to be sent to an observation home. Unfortunately, at least in the areas where I have worked, a lot of times the JJ board, which is headed by a magistrate, also looks at the juvenile as a criminal of a younger age, rather than as a child who is in need of reformative, process. The reformative aspect of the JJ Act is something that at times gets clouded, and the JJ board mechanically starts to deal with the child as if he was a criminal, and the trial needs to begin, rather than to take a broad, humane, and reformative, stance in the matter. The other problem that comes is that the observation homes, by whatever name they may be in different states, are firstly, observation homes are common for children in conflict with the law, and children who need care. For example, a runaway child, or a child who's got lost. So that is one issue. The other is that once again, the government system being what it is, the observation homes don't have that kind of conducive atmosphere and environment where the reformative process is furthered. Rather, it becomes a prison by another name, which is something which is totally against the whole concept of observation homes. But going back to what Shyni said, I would like to highlight that when a juvenile commits a crime, for example, a child in school steals something or misbehaves with a colleague or has a fight, it is not necessary that an FIR is registered and a police case is initiated. The police will probably, do some counseling and then ensure that there's no repeat of that offense, place him before the JJ board, and the JJ board will take make a decision depending upon the circumstances of the case. The JJ board is very importantly manned not only by the magistrate but by two social workers who are expected to have expertise and experience in handling of children. So that the whole idea behind these two members is that they would take a humane, reformative view when a child is brought before them.
Right.
I would like to add on to what Ahmed sir had said, that if you look at statistics, something very alarming is, like as we were discussing in petty and serious cases, there is no requirement of an FIR even if the child has committed that offense on his own. But combined with an adult, an FIR is registered. But if you look at in what are the cases that children are being detained at present in different homes, you will find staggeringly that the figures are in offences which come under petty and serious offences. That means where there is no FIR is to be registered, where apprehension is required, the police is actually registering FIRs, the police is actually apprehending juveniles unnecessarily, and on production, the magistrates are also detaining them unnecessarily. Because if you look at crime in India statistics which are available, the detention do not match with what it should be as per the petty, serious, and heinous categories. I think that kind of sensitivity that is required to deal with children, to look at it from a reformatory angle, that is lacking in the system. And as sir said, the importance of training. What really happens, one officer in a police station is designated as child welfare police officer, and there is a special juvenile police unit in every district in the SP's office. So those officers get trained, and maybe in another 6 months they get transferred out, and a new batch of officers come. So this is true with respect to police officers across the country, and with respect to the sensitivity that is required for members in the child welfare committee or the JJ board, the social workers that sir was referring to. They are not necessarily in the board because they have had sensitivity towards child. There are, because the qualifications have not been defined. The people, undeserving people, are also into the board and the welfare committees. So these areas are getting streamlined, where some of the states have started prescribing the criteria of selection of these crucial people in juvenile justice. So this is a challenge, and we are, like, as a state, negotiating it so that it is in the interest of the child.
Right. No, thank you for highlighting those challenges, both of you. But I wanted to actually talk a little bit on the other aspect of JJ Act, right? One is, of course, child in conflict with law, which is the criminal side of things. But we also have children in need of care and protection, which is the welfare side of things. And critically, or rather surprisingly, both of these elements are covered and governed by a single legislation. And like Mr. Ahmed was pointing out, sometimes the lines get blurred because, both kinds of juveniles are sent to the same observation home and are subjected to similar treatment, while their needs might be very different. And there might even be instances where a child could fall in both categories. For example, if a child is abducted, trafficked, and is made to peddle drugs by a gangster, then essentially he's a perpetrator as well as a victim, right? So there is sort of like a duality in that sense. But the overall act also is a little contradictory, I feel, because it tries to balance both these aspects under a single umbrella. So we have spoken at length about children in conflict with law, but now I want to know from you, Ms. Shyni, as to what happens for two children in need of care and protection. How are these identified? What is the institutional mechanism there? When are they kept at observation homes? At what point are they released, and so on?
Sri, first, before we discuss children in need of care and protection, I would like to say that there is no inherent contradiction in the Act, because if you've looked at the title of the Act, it is Juvenile Justice, Care and Protection of Children Act. So we generally classify children in these two broad categories, but I would like to clarify that most of the children in need of children in conflict with law are also actually children who need care and protection. So the Act envisages that all children should be protected, and there is no criminal, in juvenile justice, there is no criminal side of things. With respect to children in conflict with law also, they are being sent to the welfare side of things. That is why this Act is important, and that is the soul of the Act, that we are not looking at its criminal, and there is no retribution. It's only like rehabilitation, reformation, social integration. And coming back to your point of children in need of care and protection, there are like so many children that we see daily. The orphaned children, the children who are trafficked, the children who are in the streets, the children who are vulnerable, the children who are victims of various kinds of crime. They are in 12 different categories as has been classified in the Act. When such a children can come to the radar of either the police or any of the child protection agencies, whether it is Childline or District Child Protection Officer or CWC or whatever, and then such children are produced not before the Juvenile Justice Board, as is done in the case of a child in conflict with law, but before the Child Welfare Committee, whose primary mandate is to take after the care and protection, issue orders for rehabilitation of the child. There are also, if the child needs to be placed under the custody of somebody, so there are like fit persons whom the Child Welfare Committee can notify, and the child can be placed under the custody of a fit person. And how do you identify the fit persons? These are defined in the Act. Or maybe a child can be put to monitoring. There can be a plan for it, and the probation district child protection officer monitors it. So there are, and such children do not go to the 2015 Act has made a little bit difference on the nomenclature. So these children are actually kept in the childcare institutions, and the children in conflict with law, mostly if the board accepts that the inquiry is to be done, so they are kept at the observation homes. So these children in need of care and protection will be taken care in the childcare institutions. But as sir was like saying, mostly what happens is like there because the CCA institutions may not be necessarily having a school nearby. The institution caretakers are of the feeling that maybe the child would run away. So there are like issues with respect to actually accessing education and such kind of things. So mostly what I've seen in CCIs, they provide the books and the child sits there and studies and maybe go and give the examination. But then that denial from accessing a formal schooling happens in many of such cases. We have setting up systems, and I hope that these things will get stabilized in due course so that they are sent into the formal schooling system and are able to pursue their educational career like everybody else. But another issue is that these children can be kept in such homes only up to 18 years. And from 18 to 21 years, there is some more support. They go into a place of safety and another facility where government provides some kind of a monetary support also for them to like settle in their life, apply for jobs. So that is how a child in need of care and protection is taken care of. There are projects for them, their care is monitored, and they are within the system, and because they are in the institutional care of the state, so the responsibility is much higher, so that they are not exploited. You must have seen that there are like once in a while news reports of so many abuses that happen in childcare institutions. So that child-friendly atmosphere, the child-friendly mechanisms, the people with that kind of a sensitivity, there is a lot more. There are already people hugely sensitive to these issues, but there are like aberrations. So these things need to be looked into in future.
Stay tuned to All Things Policy. We'll be right back after a short commercial break. Right. So let's move on, or rather move back to the issue of children in conflict with law, because I wanted to discuss two or three very important issues which have come up in recent years regarding the treatment of these children in conflict with law under the Juvenile Justice Act. Because when the 2015 Act was enacted, one of the significant changes it brought about was, allowing certain categories of children who commit certain categories of crimes to be treated as adults in regular criminal courts. So what the law says is, if a child between the ages of 16 to 18 commits a heinous offense, which you pointed out earlier is any offense which carries a punishment of 7 years or more, then the Juvenile Justice Board essentially conducts a preliminary assessment, and if it's found fit that the child can be tried as an adult, then the child is committed to a regular criminal court to face punishment or face trial and punishment. This change was essentially, the background to this change was the Nirbhaya incident, where one of the accused or the perpetrators who was involved was a juvenile, and a lot of demands were made for stricter laws because this juvenile was let off after 3 years in observation home, as the law stood back then. When this shift was made in 2015, this was very polarizing. There was a lot of debate in the public sphere. People felt that, we need stronger punishments for children between 16 to 18 who commit these kind of heinous offenses, while the other side felt that, this is a violation of child rights because you have to treat everyone under the age of 18 equally, and so on. Now, nearly 8 years has passed since this amendment was made. This process has been implemented across the country. So I want to know from both of you, what has the experience been like? What are the disadvantages and advantages of this move? Has it impacted juvenile justice delivery? Has it actually resulted in increased deterrence, or is it just another instance of violation of child rights? So what has it been like?
Sri, I have a very strong opinion on this. Had there been no juvenile accused in Nirbhaya case, as you had pointed out, probably this amendment would not have come. From what I've understood, the juvenile accused in Nirbhaya case was over-vilified in the media, and almost so many people were out on the road demanding that he be hanged, if you remember those footages that were coming. But this is actually not the truth, because as I've found in a lot of well-researched articles, the fact that this juvenile accused was the most violent is not true, and the Juvenile Justice Board magistrate has recorded this fact in his disposal order. The Delhi police had also reportedly clarified that this is not true, but the media did not care to relay it or report it. The parliament, after this issue, had amended the act and brought in the 16 to 18 category separate, and where there is a provision for referring them for adult trial. So that punishment more than the basic intention at that time was to avoid an imprisonment more than 3 years. This transfer to the adult system is to be done after a preliminary assessment, as you were just mentioning. So this preliminary assessment is done to assess the child's mental and physical capacity to commit the offense, the ability to understand the consequences of the offense, and the circumstances in which the child committed the crime will also be looked into. The Juvenile Justice Board should, or the Act mandates that, if necessary, can take the assistance of psychologists or psychosocial experts. But the challenge here is that many psychologists are of the opinion that it's not possible to objectively assess this mental capacity in these lines as is defined in the section. And many also do not believe that this can be fairly done. The second challenge is that we have juvenile justice boards and such issues coming up in all districts in the country, and there are juvenile justice boards in every district, as you know. Like in Odisha, I am from Odisha, so we have only like one college here which offers graduate and postgraduate course, that is in Bhubaneswar. So imagine, see, we really do not have clinical psychologists or like that kind of an experts available to JJ magistrates to take those decisions and do the preliminary assessment in a professional manner. Coming to how the psychologists do the assessment whenever they have been tasked. If you can look at a few of their orders, so mostly like out of curiosity, I have collected some of them and looked at it. Many a times this is only like 2 or 3 sentences where they have recorded why this child should be referred to the adult trial. Similarly, if you look at orders of magistrate after the preliminary assessment as to why the child is referred for adult trial, in most of the instances you will find there is no justification at all. In many instances, the higher courts have been turning it down too. So this is a major challenge that comes up when you discuss 16 to 18 category. And in many such instances where the child actually goes for adult trial, you can find that it is mostly those cases in which the media has sensationalized the matter, or when the police is entrusted to pursue this case. So the police influences, and as you know, the Juvenile Justice Board consists of a principal magistrate and maybe 2 social workers. In most of the remote districts in India, the social workers are of not that confident category where they have their own opinion and assert their opinion, or like have a difference of opinion with the principal magistrate. So mostly it is a prosecution which would want the trial to be the child to be shifted, transferred to the adult system. So this is a challenge. And in my field experience, I've seen that the matter of preliminary assessment is not done professionally, and the issue of competence of the psychologist is also a matter of concern. And this is some amendment which do not fit into the guiding principles that is initially mentioned in the Act. So that's it.
Yeah, so you pointed multiple issues, right? I mean, one is lack of state capacity in conducting a preliminary inquiry. The other is the perfunctory manner in which, magistrates are just sending juveniles to be tried as adults. And the other thing being, how media frenzy often leads to these kind of policy measures being enacted, which may or may not be suitable. Mr. Ahmed, I want to know your thoughts also on this issue. Would you agree with what Ms. Shyni has said, or would you disagree? What do you think?
I think there is no way one can not agree with Shiny's opinion. The the exemption that has been made in respect of children of 16 to 18 is virtually in contradiction with the purpose and the spirit behind the enactment of the JJ Act. The data available shows that a very vast majority of the cases of juvenile delinquency are related to either rioting or outraging the modesty of a lady or a girl, and probably drug peddling. So to in the teeth of this kind of data, to make these exemptions after the Nirbhaya case is, to my mind, an example of overreaction and probably, as Shyni said, of media frenzy. And I think a more cool-headed view needs to be taken at some stage, and I'm sure at some stage the matter will come up before the high courts and the Supreme Court, and a more deliberative action would be taken. Now, coming back to the capacity and the competence of the JJ board members, I've already mentioned that their competence to handle a very sensitive matter is average at best. The availability of such people is very low, and in fact, there is a good case for having certificate courses in clinical psychology, wherein there is theoretical input and also there is some field work with children, so that at least there's a cadre of people available from who have some competence in the area. And it is from such cadre of people that JJ board members need to be selected or nominated. Right now, it has become a method of just political patronage, unfortunately, and that is not the best way to go about it. You see, the whole system of the whole process of the JJ Act being used has been given to the police, which I think itself has a wrong thought behind it. I mean, the police is not trained, nor is it equipped to do this kind of sensitive work. They should be assisting social workers in this area rather than being the lead, and with the social workers assisting them. I think there's a need to change this, the use and the practice of the JJ Act from so that the reformative aspect of it becomes highlighted and becomes the core thing, in the core focus and the core spirit in the practice of the JJ Act.
Right. That's a very interesting observation you make, that, maybe the police forces are unfit to handle the juvenile justice system itself. And maybe we should think of any alternative stakeholder who can, enforce and implement this. I think much thought can be given into that, because essentially the police is trained in law and order and criminal investigation of offenses committed by adults, and they may not specialize in juvenile justice at all. So thank you for highlighting that. Now I wanted to sort of discuss another issue which has been in the news for quite some time now, and it also comes a bit from my personal experience. Once when I was interning in college, I had the opportunity to visit an observation home, and from whatever my limited interactions there, I gathered that many children had been incarcerated, or rather kept there because they were involved in sexual offenses, and this turned out to be cases where they consensually engaged in sexual activities with people their age, basically children, but due to some complaint by the family or something and so on, they had ended up at the observation home, right? Now this is a very contentious issue, because here, if say two children, both of who are minor, under the age of 18, engage in consensual, and I'm putting the word consensual in brackets here because we know children under the age of 18 cannot give consent by law. If they engage in such activities, the law treats them as criminal, but the fact of the matter is both of them can be seen as perpetrators and victims, right? Plus there is also the angle of social reality, because this is happening around us. It's not like we can stop this by criminalizing it or putting children in juvenile homes and so on. And in fact, in the recent years, we have had several high courts who have come out and said that, for children between the age of 16 to 18, we need to reduce the rigors of POCSO, which is the Protection of Children from Sexual Offences Act of 2013, and make an exemption to them so that, consensual relationship between members of the same age bracket is exempted, right? Now the social norms are changing, social realities are changing. Courts are also showing leniency towards minors who are caught in such situations. So essentially, there is a conflict between what the POCSO says, how the juvenile justice system operates, and what the reality is. So I want to know from you, what are your thoughts on this issue? I know this is very contentious, but I want to know if there are any policy measures that we can implement that sort of solves this problem and does not end up, putting children in juvenile homes for this reason.
Yes, Sri. This is basically what the police officers generally refer to as technical cases. So you would have seen this Enfold study where they have been referring to such cases as romantic cases. So wonderful studies have come up as to how much this impacts adolescents, whether the act is protecting the adolescents as it envisaged it should, or whether it is harming the adolescents by criminalizing normal sexual behavior during adolescence. In many of these cases involving elopement, the accused need not always be a child. Sometimes they are adult accused, sometimes there are juvenile accused also. There was a recent case of an adolescent in such a romantic case committing suicide in one of the homes. That is the extent to which it is harming children. At present, the age of consent is 18 years, and therefore, if anyone indulges in sexual relationship with a child, it is an offense, irrespective of whether there was consent or no offense. You were referring to it also. So this is called a strict liability in law. So there is no consensual or non-consensual. There is no question of it, because every such act becomes automatically criminal because of the strict liability clause. But as a practitioner who has seen the ground realities, I would like to see the age of consent being brought to what it was prior to 2012, that is 16 years as recommended by J.S. Verma Committee in 2013, and decriminalization of consensual, non-exploitative sex between adolescents. We are also accepting the principle of dignity and worth as one of the guiding principles in the JJ Act. So if you look at this, so we are taking away the agency of the child with respect to his bodily integrity. So there are these issues have been dealt in some of the European countries in better ways, rather than putting all these together, a lot of offenses together under one bracket. Which is some of the European countries have come out with the concept of age differential between two consenting individuals. So they deal it completely in a different way. In US, they call it Romeo and Juliet laws. So we need to think of different ways in which we need to look at these offenses, whether we need to criminalize these offenses. And also, as a nation, we need to think what should determine the age of consent. As we all know, the WCD draft had 16 years. The Law Commission had recommended 16 years. The J.S. Verma Committee had recommended 16 years. But when it went to the parliamentary panel, I think it was raised to 18. So what should determine this age of consent? Whether it should be politics, whether it should be psychology, whether it should be neurology. So we as a nation should settle this and get out of the trap of a patriarchal mindset, which is always eager to control sexuality, and more particularly of girls. So there is more research also to be conducted, and whenever the European countries have reduced the age of consent, they have followed it up with a lot of research. So it did not show that suddenly the sexual behavior among adolescent children increased, or it did not show that there were increase in teenage pregnancies. So it's so many misconceptions that we have about this in our mind needs to go. And as you were referring, many high courts. I think you can see one high court after the other making a sort of request to the parliament to legislate or relook into it. So this is an area which also in a way trivializes other serious offenses against children, because the police officers deal with majority of many cases of technical nature like this, and then when a real case comes they start doubting that whether when the girl says that this is like non-consensual, they start asking questions like, why did you go in the night, who was that boy, and all those kind of questions which are unnecessary. But that is because they deal with a lot of such cases where the girls do not consider themselves as victims. And if you can see, the complainants in most of these cases are parents. And only in cases, have you seen in well-off families categories, POXO Act cases? No, because they discuss between families and sort it out. But the issues come up mostly when the boy whom the girl had identified is not suitable to the father or not suitable to the family, he is from a different caste or from a different community. When the boy is not acceptable, that is when the matter is reported to the police station. So are we not taking away, when we are saying the child is to be given the right to decide all or to choose things which affect them, then isn't this also one such right, one such guiding principle where the child, where we are taking away that right from the child, where the child is not being allowed to decide? Because even the POXO criminalizes not just physical relationship, it criminalizes even other activities like kiss or touch or other things. So we need to really relook at the act, do a little bit more studies. A lot of studies have already been done, and whether the act, as it says, protection of children from sexual offences, whether that act fulfills the mandate or whether it actually causes harm to children or not, is something that needs to be seriously looked into. Thank you.
Right. So, I mean, I'm not very hopeful of any legislative changes here because the parliament, in fact, is considering a proposal to raise the age of marriage to 21. I mean, if 18 is the age of maturity and it's the age at which, one can essentially vote to elect your political leaders, but you cannot elect your own spouse at that age. I mean, it's a little strange. But like you mentioned, I'm more hopeful of a change coming in from the High Courts or from the Supreme Court. Yeah, you wanted to add something?
Yeah, I wanted to say that if we look at Madras High Court judgment on this, and what the Madras High Court, see what happens is, we have also done a little bit of study here where, like, while the trial is going on, if you look at what has happened with the girl and the boy, like close to 51, when I did a study on some time in Odisha, I found that 51% of the girls who were supposedly the victims were already like either staying with the boy or like waiting to marry him because she has not reached that age. So it is like that. So what the Madras High Court had done is like directed the Director General of Police to issue a circular saying that in cases of under POXO, which is consensual and non-exploitative, he wanted the police officers to be directed that no arrest should be made. So following this instruction from the Juvenile Justice Committee of the Madras High Court, the Director General of Police Tamil Nadu has issued a circular to the old field formations requesting them that you can charge sheet because the law says so, but there is no requirement of immediate arrest of the accused. So there has been also instances, I think the Assam had undertaken a drive where like you all of a sudden found hundreds of babies along with their mothers in different homes because they were neither taken by the own families and their husbands landed up in jail. So if you look at child marriage statistics, if you look at census data of 2011, it's very interesting. Like in Odisha also, the child marriages in 2001 census was between 30 and 35%. So imagine if we are going to register that many number of POXO cases, it's like in lakhs. So this is like, you are not very hopeful of legislative changes, but pending that, I am very hopeful of these kind of initiatives that can be taken where to some extent, not to full extent, legislative change is maybe the one because Parliament is the one to legislate on this. But pending that, these kind of instructions by either the Juvenile Justice Committee or by the state police chiefs, the DGs, can to some extent mitigate the problems being faced by such
Right.
adolescents.
Yeah, that's an excellent example of a pragmatic and progressive approach that high courts have taken. It's within the constraints of the law to do justice in such cases, right? So, Mr. Ahmed, what are your thoughts on this? How would you see us solving this problem? And what do you think are the measures that we can take?
I think Shiny has given a very useful and very knowledgeable, comment upon this about how there seems to be a mismatch between the social realities and the will of the parliament. In fact, she also hinted about the parliament being manned by uh, people who are not yet accepting of the social changes that are happening among the youth as far as their behavior in such matters is concerned. I would only like to add to what Shani is saying by saying that the availability of almost free data and the social media and the use of pornography by children. These are all realities. That is another area that we should be looking at because that is something that often is at the back of such behavior by children who are not yet fully aware of the consequences of their action.
Right. So the discussion we just had actually leads me to the final part of the conversation that I wanted to have with both of you today. And this relates to something known as the principle of diversion, which I think Ms. Shiny pointed out to me a couple of days back. So the JJ Act actually incorporates this principle called diversion, which says measures for dealing with children in conflict with law without resort to judicial proceedings shall be promoted unless it is in the best interest of the child or the society as a whole. So this essentially is a signal that we can be thinking out of the box, we can be thinking outside of the judicial proceedings, outside of courts and observation homes and so on, to do justice in situations where juvenile delinquency is involved. So Ms. Shiny, I want to know your closing thoughts on this principle of diversion, as to what is the status of this. Has there been any developments? Has there been any thinking? There are institutions which are looking at this, so what's going on?
Sri, if you look at the JJ Act, it cites principle of diversion as one of the guiding principles. It is a wonderful concept and an internationally recognized concept. So it basically means that, as you said, a child is dealt without it touching or coming into the judicial proceedings. But if you look at the act in detail, you will find almost every children in conflict with law, as envisaged in the later part of the act, actually touches the is brought even in petty and serious offences. A child is actually brought, so he actually has to negotiate with the justice system formal in India. So the principle of diversion as internationally recognized is different from the framework that we have in India. And we often hear people saying that police officers should also start doing diversions, but there are there is a gap in it in the law at present, and there are no detailed guidelines on it as to how to effect the diversions. Who all are the people who can do these diversions? Though the act recognizes the principle of diversion as a guiding principle, further details have not been enumerated in the act, and it is a wonderful. So these will slowly evolve, maybe in the next amendment or maybe by way of guidelines that are issued in the rules. Maybe the states will come out with amendments in the rules to streamline these things. But without knowing that this is diversion, a lot of police officers, like Javed sir was saying, they may not even take, they will just warn and let go. So that is actually the police officer might be doing diversions while standing on traffic duty in a road also, which may actually help the child also in many times. So this principle of diversion is a very important concept, and what we need to do is, in internationally, the community based organizations, the family the neighborhood people or like who have been identified have been like involved with diversion activities. Whereas in India, we have taken it everything to ourselves. We have not involved. We are not involving the family in these. We have to involve the community in these. We have not identified people who can monitor the child within his own community. So these things will slowly come, and this is a very, very important thing. And we cannot, as a state, take everything to ourselves. We have to have very detailed diversion guidelines and put in mechanisms in place. And pending that, a lot of police officers, child protection officers need to understand this concept and move ahead. And diversion from judicial proceedings is also like diversion of the child in a way from offending. So as long as it helps the child, this is a principle that we should adopt. And I think this is one of the core soul of the POXO. Sorry, the JJ Act. It's one of the soul. So I would, because I think we are going to like wind up by this. If you remember the recent movie Oppenheimer, where there's a conversation between Oppenheimer and Niels Bohr, where he when Oppenheimer was a little low because he was not able to do algebra, so Niels Bohr asked him, forget all those algebra and math, which you are not like maybe think that you are not good at. But he says, are you able to hear, Robert? Are you able to hear the music? So he means the universal music. So this is what is important in JJ. Whether we have the framework, we have the legislations, we have excellent guiding principles. But whether you have it in your soul, whether you have that welfare orientation, whether you have that right-based thinking, whether you feel that the child deserves a different kind of a treatment, whether you feel that the child needs to be given a second chance, as you said, the fresh start. These are the things that are very, very important, and in that, diversion is a very, very important principle.
Right. And the other observation you made, which I really liked, was about the predominance of state, right? How we have assumed that all problems can be solved by state and more state. But this actually takes me back to what the framework we use at Takshashila to think about things, which is of Samaj, Sarkar, and Bazaar, the state, markets, and society. So not every problem needs to be solved by the state and state alone. The society and markets have an important role to play. And especially when we think of a lot of issues with juvenile justice, I think the society has a large role to play as well, which you mentioned very right. So thank you very much, Ms. Shyni, for joining me on this conversation today. It was very informative, very enlightening to me. And also to you, Mr. Ahmad. Thanks again for being part of Police Chowki, and see you again.
Thank you. Bye-bye.
Thank you, Sri. Thank you, sir.
Thank you.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.